self-education by attending several seminars on biodiversity convention, law of environment protection, among others, as well as your statement made a while ago as regards climate change. We're all familiar with the 2008 Supreme Court ruling issued concerning the continuing mandamus in the area of Manila Bay, especially the preservation of the area. This is just a personal question, Justice. What are your thoughts concerning the ongoing reclamation 2 kilometers away from here in that same area? Is the continuing mandamus ruling still in effect, or was it violated, or is there a need for another petition for a writ of kalikasan? Your thoughts on this, Justice?
My thoughts, first of all, I have to defer also to the thoughts of the Honorable Supreme Court Justices. They have to deliberate on that if there is a violation on the continuing mandamus. Now, since the President has already issued a sort of suspension directive against the reclamation projects, now is the time for the Supreme Court Justices to deliberate and find out if there is really a violation. Then the Supreme Court and the President may collaborate, not necessarily officially, in order to determine if there is really a violation. If there is none, then the reclamation may continue.
So you are in favor of reclamation? There is no violation?
No, Your Honor, right now, no, not in favor. Because there's, I have to defer to the directive of the President.
But in case there is no violation, the process was followed, but from your studies here, environmental impact would be shown. Would it be something worth looking into?
Yes, Your Honor, it's worth looking into, and maybe another case may be filed so that the issue may be resolved head-on.
Thank you, Justice. I have 2 more questions. Right now, we created a special Maritime and Admiralty Zone Committee, which I chair. It has something to do with the pending bills in the Senate that would require consideration and further deliberation, the Maritime Zone bills. Under Constitution, Article 1, 1987 Constitution, the national territory is defined. Do we really need to have another law, a domestic law, to really define the boundaries, the metes and bounds of the Philippines, including our territorial waters, our exclusive economic zone, hand in hand with the arbitral ruling? Is there a need for that, or are all these international rulings as well as the treaties that we signed incorporated by virtue of the doctrine of incorporation? Do we need to have a law, or do we just incorporate all of this per your understanding, Justice?
Based on my understanding, Your Honor, there need not be another law. All that is needed is to revisit all those relevant laws and international agreements so that, again, we need to be educated as to the territorial boundaries of our country, as to what portion of the sea we have to exercise our sovereignty.
I appreciate your answer, Justice, but there are several views now circulating. One is to have a judicial recognition, for instance, of the arbitral ruling. It probably might not fall under a separate treaty, but under Rule 39 of our Rules of Court. Decisions issued by foreign courts or via arbitration can or should be recognized by Philippine courts. You subscribe to that? Is it proper to judicially recognize the 2016 Hague arbitral ruling to make it more fortified, to strengthen it more?
In my personal opinion, Your Honor, there need not be judicial recognition.
Need.
No more need, Your Honor.
And why?
Because there is no such provision in the Constitution that any arbitral ruling should be recognized first by the judiciary. So it should be respected. It should have been respected since 2016 when the decision of the arbitral tribunal was rendered.
So, in effect, after the issuance of the arbitral ruling, all courts should take judicial notice.
Yes, Your Honor.
So, in effect, even if there's no case filed under Rule 39, all courts, including the Court of Appeals, should take judicial notice.
Yes, Your Honor.
Thank you, Justice. My final question. Basically, the job of a presiding justice would be management, administrative. And one of the issues confronting the Court of Appeals right now is not just case assignment, docket management, but resource allocation. And I would now be delving on what one of the SONA directives of the President, the amendment of Republic Act 9184, and that's the procurement law. Having been a justice for quite some time, do you see any changes? Do you see any issues right now relative to the procurement procedure of the Court of Appeals? And if appointed as presiding justice, how will you address if there are any procurement problems, given the resource limitations that you have right now?
First of all, Your Honor, I have to confer with the committee in charge of the procurement and find out any of their concerns. And I think we should just focus on eliminating red tape.
Thank you. My dear colleagues, I have no further questions. I yield my time.